When they started to put together the package, which is a package of no fault of counsel fees, there was also a post-divorce maintenance bill introduced, which basically created a formula for how maintenance should be awarded, and it also had a formula for duration. The duration was tied to the length of the marriage. There was a statutory language which indicated if you were married a certain number of years, you got support for a certain number of years. And the support itself was based upon a couple of variations of a formula. It basically said we'll take 30% of the higher earners or higher incomes person's income. We'll deduct from that 20% of the lower earning person's income. We'll put that number aside. Then we'll take 40% of the combined income, and from that we'll deduct what the lower earner made, and we'll compare number one and number two, and the lower number is the number of maintenance. There's issues about how high in income you go or don't go, and then there always were factors which a court could look to beyond the simple formula. While that may or may not work on a post-divorce maintenance situation, it almost certainly does not work on a temporary maintenance situation. And if you'll forgive me, let me give you a couple of examples. I want to take some simple examples. I make $150,000 a year, and my wife doesn't work. We live together in Westchester County, and as most people know, we spend every penny we make between our living and our taxes. But if you look at the temporary maintenance bill, when my wife sues me for divorce, or I sue her for divorce, and somebody forces a motion for temporary maintenance, because they don't pay, they change the status quo, if you apply the formula to that amount, my obligation to my wife is 30% of $150,000, which the last time I looked was $45,000. Deductible to me, reportable to her, from which she has to pay all the expenses of her life. Doesn't make a whole lot of sense. Change the formula. I make 150, she makes 100. 30% of 150 is 45, 20% of 100 is 20. You subtract the 20 from the 45, you get $25,000. Now you go to the second example. I make 150, she makes 100, 250, 40% is 100. You deduct the 100 she makes, she would get no support. Even though we're living on the whole 250 that we make, pendente lighting. And what happened? What happened is that they couldn't get through the post-divorce maintenance bill, so they quickly rewrote it at virtually the last minute. In fact, if you look at the drafting, there are terrible inconsistencies in the statute, the temporary maintenance statute, because they didn't catch all the things which ought to be taken out when it was written for post-divorce maintenance. And by the way, even the temporary maintenance bill allows a court to ignore the formula and to apply factors. And I suspect that that's what's going to happen, because I think when dependent spouses look at this, they're going to think about this in terms of, why would I want to ask for the formula? It won't get me enough money. You know, the funny thing is that people thought of no fault as being for the men and formalistic approaches to temporary maintenance for the women or the more dependent spouse, if I can be excused from being sexist. I'm just being traditional. Well, the reality is that no-fault divorce is going to help a lot of women who couldn't get a divorce because they couldn't move out of the state. And if the formulas are applied, it's going to hurt lots of dependent spouses, at least on an interim basis. If you took this bill and made it post-divorce, it may work, but it certainly will not work on an interim basis.
Do you think it was the legislation's intent to make this guideline mechanics a cookie-cutter approach?
Absolutely. They've already got out a worksheet for temporary maintenance guidelines on the OCA website, which allows you to fill in all the numbers and figure it all out. Somewhat like child support Standards Act. You take 25% of the first $130,000 of somebody's income, and that's child support.
Well, the first part of the calculation is almost identical to CSSA.
It's exactly. In fact, you use the same definition of income is under CSA. When I talked about $150,000, I ignored the fact that you deduct FICA and Medicare. But sure, it's a cookie cutter approach because that is what people want at the lower income level.
So once this is tested and once perhaps practitioners and litigants feel that it's not doing what it was intended to do, how long do you think it will take for it to be redone or amended?
Okay. Well, you have to remember the following. When they passed the temporary maintenance bill, they also passed a second part of that bill, which referred the issue of reform of our divorce laws, especially maintenance, to the Law Revision Commission, which is now studying the issues and which has till, I think, next May to issue a first report and next December to issue a final report. The thought being that they will come up with a new approach to maintenance, which makes it much more palatable and it makes it easier to administer justice. I need to remind you, however, that they really got it wrong because it doesn't work for temporary maintenance and it won't ever work for temporary maintenance because until you separate people, until you have two households, you can't keep your current household on the kind of percentages we're talking about. But do I think that there ultimately may be some formula? Yes. I would think that ultimately people are going to recognize that there is a economic level of our society which needs a cookie cutter approach, which needs to know if I make $100,000 a year and I have one child, I'm going to pay $17,000 in child support. And if I make $100,000 a year and my wife makes nothing, I'm going to pay X dollars in alimony or maintenance, and will then go redo the child support. Remember, maintenance is a deduction from income for child support purposes. I think it ultimately will be imposed on us and may very well work at a certain economic level. On the other hand, I think it's not going to work at the higher economic levels, and I don't think there was ever an intention to do so.
What does the bill say when the party that's responsible for paying defaults? What are the issues there?
So the statute has within it the following language. When a party defaults and there is no evidence of income presented, the court shall order temporary maintenance based on the standard of living and the needs of the payee prior to commencement, whichever is greater. Now, let me explain what the word default means. Default means somebody makes an application for support and you don't put in answering papers or you put in improper answering papers. Remember, like it or not, this statute says I need to see an income statement in order to do the formula. Well, if somebody doesn't produce a tax return or an affidavit, he or she's in default. Moreover, when you're dealing with what we'll call the cash economy, where people are afraid to sign an affidavit under oath as to their income when their living standard is much higher, I'm not going to sign anything. Do what you want, Judge. But this is intended to make it clear that you can't frustrate justice by simply not producing the papers. That in effect, if you don't produce the papers that I, the judge, need to render an appropriate decision on maintenance, that I'm going to look at the lifestyle that your spouse has presented, and I'm going to accept it. And I'm going to order you pay pursuant to it.
Let's move on to another topic, the modification of child support. The Family Court Act was amended to conform to provisions governing the modification of child support to the domestic relations law. What did this change allow?
Okay, so there are the following changes. Again, this is all perspective, and now we're talking about what happens when an order for child support is entered into after, and I think this is the October 13th, okay? So if an order on child support is entered into after October 13th of 2010, you can get a modification pursuant to the following. One, you show a substantial change of circumstances. Well, frankly, that was always the law. If you can come in and show we had a trial, the court fixed an amount of child support, and now he's making a whole lot more, or I'm making a whole lot less, and you could prove that there was a substantial change, you could get a modification. But this new bill adds two other grounds. You have the right to go in for modification when 3 years have passed since the last order was entered, modified or adjusted. So in effect, every 3 years you can go in and make an allegation that he's making more, I need more, and you'll get an entree into the courthouse. Now, I don't know how the courts are going to monitor these. I don't know what they're going to require. Because normally when you make an application for a modification, you have to produce a financial affidavit and some proof which allows you to require the other side to produce a financial affidavit. And I think if you walk in and say, well, I have reason to believe my spouse is making a lot more money, and he or she is not making a lot more money, and they produce a document, I think those people are going to have counsel fees awarded against them. But it is an entree and allows a court to look at it. And the second one is, and this is very important in these troubling economic times, if there's been a 15% reduction or increase in income by either party since the last order, and this isn't voluntary, and if you lost your job, you've looked for a job, it gives you the right to go in and try to get a modification, either upward or downward. What's most interesting to the lawyers is how this affects orders which are entered based upon agreements. See, the standard to modify child support by agreement has always been harder. There are a couple of cases, Bolden and Brescia, you had to show unanticipated change of circumstances, you had to show that the children's needs are not being met. And if you didn't show that, you couldn't modify the agreement, and so there was little point in modifying the order when you were trying to get more. However, this statute does not seem to make a distinction. It seems to treat post-October 13th agreements incorporated in post-October 13th orders the same as it treats an order. But we'll have to see what the courts do. You also have the right to waive the 3-year and 15% right to back to the courthouse. But if you do waive it, the agreement has to say that you're waiving it, and the judgment entered on it or the order entered on it has to explain that you have a right to it and say whether or not you've waived it.